Hello, everybody. This is Jennifer Schaus coming to you live from Washington, D.C. today, and thanks for joining us in our Webinar Wednesday series. We've been hosting webinars every Wednesday for the last few years, and we've got quite a few webinars in our archives and quite a few more still to cover for the rest of the year. All the webinars are complimentary. We do record them. You can find them on our YouTube channel and on our website. The current schedule is also on our website. And in the interest of time, we do not take questions. So if you have questions for today's speaker, who is David Dempsey, his contact information will be provided on the last slide. A little bit about us before we get started. We're based in downtown DC and provide professional services for government contractors who are product companies, service companies, software firms. Some of those services are listed there on the screen. You can see, including GSA schedules, proposal writing, contract administration, marketing and business development, and more. Some upcoming events that we wanted to let everybody know about. October 24th, we're teaching a teaming and partnering class in Maryland, and on December 3rd, we have our 4th annual Doing Business with DoD and the Intel Community. That's in partnership with the Virginia PTAC, and that takes place over at the George Mason University in Arlington, Virginia. You can find both of these links on our website. We hope that you'll join us. We do offer advertising in our newsletter, which goes out every Monday at 11 a.m. We reach almost 16,000 subscribers, most of which are government and government contractors. So without further ado, David Dempsey is our speaker today. He's going to be covering cybersecurity, a very important topic for all the government contractors. His background is listed here, and I'll move over to the next slide here and let David take over. So David, thanks so much for joining us today, and the floor is all yours.
Thank you. I'll get started right away. Good morning, everyone. Appreciate you listening in. If we can go 2 slides, I think Jennifer will get to the background. The next one, please. Okay, this is on cybersecurity and it's focusing on NARA, NIST, and OSD. And I start out with the 2 statutes here, and NARA, because NARA established a uniform program for this so-called controlled unclassified information. There's the CFR site, and then there's the Federal Register page. And I think you all should take a look at that because it's quite informative. The NARA people in particular did a very good job of explaining what they were doing and their authority for it and all. So that's not a problem with respect to authority. And I mention that because under the Information Security Oversight Office, they have recently revised the National Industrial Security Program for what we used to call DSS, and now it's the Defense Counterintelligence and Security Service. But going up to the NARA part, they have some vocabulary there. These are defined terms, and there's a CUI basic and a CUI specific. They have a difference, not a particularly complicated difference. And one CUI basic is something which the government keeps control of the information, and CUI specific is when the government keeps control of information due to a specific law or policy or regulation. Examples of CUI are everything from cost or pricing data, indirect cost submissions, business records, defense control technical information, which is subject to DoD distribution statements, et cetera. So that's just a general explanation of it. And in this Federal Register notice, you'll get some links to the CUI registry, which may become a significant element to government contracts. That remains to be seen. But let me stay in the regulation process here for a minute. If we go to the next slide, then I think you'll see what the CUI regulation incorporates. most of us are familiar with virtually all of these. And of course, I've got the asterisk marked where some of the NIST special publications are going to be updated and updated soon. So we now have a significant change, we now have some more changes coming in the NIST publications. So I want to remind you what it says in the DFARS clause. Let's see, 252.204-7012. And there it says the obligation is for the NIST publication in effect at the time of the solicitation. So at the moment, there are probably 3 versions that people could be in compliance with. So we go now to the next slide, and this is where I mentioned the supply chain requirements, because cybersecurity has been changed to not been changed, has been modified by supply chain requirements. You see these NDAAs since 2013, and there's a lot of law going on. And in 2018, in Section 807, they talked about the supply chain. Congress did in that statute and what has to be done. And then the next slide will show you the 2019 NDAA. And in Section 881, there is a statute now tying supply chain risk to national security, which hadn't been quite done before. And in Section 889, we have the Huawei prohibition, or for those familiar with government contracts, what I would call the Huawei-Berry Amendment. But in Section 889, in the implementation of this, which I'm getting to in the next slide, but not now, is they refer to Huawei Technologies companies, and there's several others in the statute, and their affiliates. Their 115 affiliates are listed in the Federal Register by the Department of Commerce, because there's a presumption of no license if you're doing business with one of these companies. So you better take a look at that. And then from a legal perspective, you have to realize that since it's now in the Federal Register and it becomes public knowledge, you're not going to have a good excuse to tell Commerce or anyone else if that you didn't know about the restriction on XYZ company because you didn't know it was an affiliate. And as you can see, that's latest August. They went through May, June, and August of the Federal Register notices, but the August one list all of them. It basically went from 64 to 115. Okay, so now in the next slide, we have what I referred to as Huawei prohibition, or the Huawei-Berry Amendment. And the 2 FAR clauses that I've cited there both came out in August of this year, not too long ago. And one is a contract obligation, that's 204-25, and the other one is a contract notice requirement, where the offeror has to say what it's going to do. The assumption, of course, of this entire set of regulations is that you know your supply chain. And that's why I mentioned earlier that you have this list of companies. The GSA plans to implement this in their schedules. They've already got the Kaspersky clause and that sort of thing. But now they're going to go with the Huawei clause. It's a little uncertain what GSA tends to do. They announced about 10 days ago that they were going to do it right away, and then nothing has happened yet. So now on the next slide, I'm going to get into the cybersecurity issues. In April 24, over a year ago, April 24th, 2018, DOD issued this guidance, and there's the website for it at the DPAP. And this was, in my estimation, the only useful thing DoD did since they started the cybersecurity program. And what that was a system for evaluating your own system security plan per NIST 800-71. And then, as you can see, this requirement's not yet implemented sort of indicates where DoD knew they were at the time. But they gave a priority to the 110 NIST items, and they gave them a rating. Okay, so for the first time, people had an idea what was expected at any level of compliance. And if you recall back in the 7012 clause, the DFARS clause, and DFAR 252-204-7008, those two clauses indicate that the adequate cybersecurity is all of the 110 NIST items. And of course, that changed about a week ago. So looking into the cybersecurity changes on the next page, I wanted to make sure that, excuse me, go to the next slide, please. I wanted to make sure you knew about the DCMA's CPSR new Appendix 24. It's about 6 pages. And what it does is explain what DCMA is going to look like for evaluating a cybersecurity plan within the context of a contractor system purchasing review. And then that happened in February, and then sure enough, in May, DCMA said we better up our threshold from 25 million to 50 million. That has not been approved yet. So at the moment, if you're a government contractor with over 25 million in contracts, then you're subject to this CPSR Appendix 24, and it's just, all I have to do is Google DCMA Contractor Purchasing Review Manual, and you'll get it. So it's easy to get to. And then last week, the Navy, in this Navy Marine Corps Acquisition Regulation Supplement, said the DFARS clause is a material requirement. So when something's a material requirement in a contract and you haven't fulfilled it, then they have, of course, the ability to reduce progress payments, terminate you for cause, or modify the contract price. And that's what that clause says. So if you go to that particular link or site, 5204-7303-1, you'll see what the Navy is doing. And this is the first time the government has imposed a penalty, or is going to consider imposing a penalty for purposes of the material requirement required by the DFARS clause. And the next page, we have what everyone is talking about now, and this will be the subject of many, many seminars over the next couple of weeks or months. This is the cybersecurity model maturity certification. Got the website there because it's far too much to discuss in any kind of 2-hour program. And what they have now is the September 2019 draft number 4. And what I've quoted there, a unified cybersecurity standard, is just right off their cover page to the CMMC, matrix they have. And what they've done here, and they identify who that is, a couple of contractors, et cetera, is they've taken these cybersecurity standards from the government and industry and tried to combine them. And as you see on the next page, you'll see that the maturity levels are in 5 groups. Basic cyber hygiene is small businesses. Immediate cyber hygiene would be small businesses with some contracts that are going to require the handling of a particular information from the government. And then we, progress. Obviously, advanced is going to be the bigs who dealing with sensitive information, classified information, etc. They have 18 domains. Some of you may recall that the NIST 171 had 14 domains. And the differences are logical, but they're also not significantly different from what NIST was already demanded in NIST Pub 171. So now we go to the next slide. I'll explain a quick overview of this. Is the first diamond there is this is what the CMMC is supposed to do. You'll see on the fourth one is that everybody dealing with DoD has to have a certification from an accredited third party, regardless of whether they're doing small items with DLA or, of course, large systems or subcontractors involved in large systems with the weapons manufacturers or the major IT providers. Now, the role of DCMA from their cybersecurity review, which we just went over, is uncertain, and the Defense Counterintelligence Services Agency is also uncertain for audits. Neither one, to my knowledge, have yet come out with anything to address the CMMC initiative, and of course they shouldn't because it's just in the draft stage. But you notice in the second diamond there, I've said that they use CUI or controlled unclassified information versus CDI, which is their contractor defense information, as that's defined in the DFARS clause. That change, I think, is significant because CUI is sort of a baseline name for this information that DoD and others want to protect. Now, you should know that this is, they plan to have draft 0.06 in November, and they plan to have releasing the version in January, version 1, the applicable one. And by June, the schedule is all, excuse me, CMMI is a typo. That should be CMMC. That the CMMC requirements will appear in RFIs. So I definitely encourage you to go and check out that website that I gave you for the CMMC. Now, in the third bullet, it says the contracting officer identifies the cybersecurity level for each contract, and it's going to appear in section L or M. So the first question, of course, to the lawyers is that protestable? And the answer is yeah. So the second question is it a winner? And the answer is likely no, because CO is going to have a reason for that, and GAO and, of course, Court of Federal Claims is not going to make a big, not going to try to overturn a contracting officer's decision on something like cybersecurity. Again, going back to the link I gave you, the site I gave you in the Federal Register for the NARA program, there's a provision in there for protesting the selection of the type of contract that has been identified as the baseline. It's in the CUI registry. That's complicated to explain without going through that, but that is a protest to somebody. My impression is it's clearly not the GAO that were talking about protests. But since everyone's CMMC level is going to be identified, you're going to have to be sure that you're qualified to what the contracting officer identifies as a CMMC level for that contract. And then the last slide here is just some observations I've got. NIST 171 compliance is difficult simply because it's seemed to be massive and somewhat of an erudite study. CMMC is going to be easier to do, as you'll see when you look at the model certification draft, which is at the website that I'd given you earlier. But you may be restricted from contracts. Familiar with the narrow regulations I just mentioned, I would take a look at that. They're seeing that you have the CFR and the Federal Register sites. And then in terms of figuring out what you want to do, if you go to the DHS website, Department of Homeland Security, and search for cyber resilience reviews, it's my opinion there that you will get exactly what the CMMC is trying to do, which DHS did 2 years ago. It won't quite be the same, obviously, but be very close. Now, the reason I mention that is because the people who put together these cyber resilience reviews for DHS are the same people doing the CMMC initiative for DOD. I just looked at it quickly because it's not worth comparing the draft to a review process. There's a lot of similarities. So trying to get a little jump on that, that's where you could go. And it's about 600 pages of guidance out of DHS. And then finally, I'm not certain this will happen, but the Navy Marine Corps guidance that they've issued on considering making the cyber security clause a material contract requirement and then acting accordingly. I would think more agencies will do that. It's just a good way to enforce the clause without having to be particularly out of line or whatever. So that concludes my presentation. I appreciate you all listening. If you have any questions, you've got my email address, and I'll be happy to try to give you a response as soon as I can. Okay, sorry, Jennifer, I'm done.
Oh, no problem. That was great information. And I'll make a quick announcement that GSA did issue a mass mod. I think it was one of your initial slides there to their, anyway, GSA did push out a mass mod to existing schedule holders for that particular clause on the Chinese telecom products.
Okay. Yeah.
And that was due, or I think it's due September 29th. Anyway, great presentation, lots of valuable information. David's contact information is here on the screen. You've got his email, you've got his phone number. Contact him for anything and everything related to cybersecurity. We've got 2 more webinars coming up, one at 12 o'clock, one at 12:30. They have separate links and separate dial-in phone numbers, so hope everybody will join us for those. This has been recorded, and we'll send the recording out later today. Thanks, everybody. Thanks, David.
Everyone. Okay. Bye.